Hi there, my name is Vrish Garabedian. I'm a real estate attorney here in California, and this video is about 3 expensive mistakes landlords should never make. The first one is self-help. Self-help is when the landlord locks out the tenant or does something on his own in violation of the law and doesn't go through the procedural channels to legally take back the property through the court system. So self-help can be locking the doors, locking the tenant out. It could be turning off the electricity, turning off the power, turning off the water, turning off any utilities that is necessary for the tenant to maintain a proper tenancy at the property. Self-help can be anything that can prevent the tenant from using the property as the way it was intended under the lease agreement or in conjunction with the landlord and the agreement with the landlord to rent the property. This is a really big no-no for landlords, and it can get them in hot water because there is public policy and there's also statutory law stating that self-help is illegal in California. You always have to go through the legal channels and provide the proper notices to be able to get the property back against the will of the tenant. Another part of self-help also include threats and intimidation that the landlord makes to the tenant. Threats can include anything like, I will call the police on you if you don't move out, or I will give a bad reference for any future landlords who end up calling me where you're trying to rent, or I will make a bad mark on your credit report, something like that in order for you to move out. Intimidation can be things like, I will call the police on you, or any sort of physical violence. In any event, intimidation is strictly prohibited. So there are statutes and laws in place in California that prevent the landlord from harassing the tenant. And anything that's intended to harass or annoy the tenant is illegal and can be a cause for liability against the landlord. So those should be strictly observed in California and not attempted at all. You should always go through the legal process. You should always go through the court system, contact an attorney who's well versed in the area of the law in order to be able to protect yourself and be able to properly get the space back without exposing yourself to liability. The second expensive mistake landlords make is by ignoring rent control. And rent control, as of 2019, was passed throughout the entire state of California through the Tenant Protection Act. The rent control that has been applied consists of just cause for eviction, and it also applies for rent control in relation to how much you can raise rents every year on your property. Certain properties are exempt from rent control and from the Tenant Protection Act, and in relation to this is in relation to residential property. Commercial properties in California are exempt from all forms of rent control. So there's no sort of cap on the amount of rent that can be charged for commercial properties, and there's no restriction on the reasons why someone can evict a commercial tenant. It comes down to the lease agreement itself. Many cities in California have also passed their own ordinances that have forms of rent control that restricts and controls what a landlord can and can't do in relation to the property if he wants to get it back from the tenant. The just cause for eviction rules state that a landlord can only take back possession of the property if he has just cause, and just cause means that there has to be certain situations that are applicable in order for the landlord to get the property back. Some of those ordinances state that you have to pay a relocation fee to the tenant if you want to evict him from the property. Under the Tenant Protection Act, the penalty or the relocation assistance payment is 1 month of rent or waiving the last month's rent. Some cities have gone even further and made it stricter and made the relocation payment more than 1 month's rent, depending on the city that the property is in. If it is subject to rent control, there might be additional penalties or relocation payments that you have to pay to the tenant in order for you to evict the tenant with just cause or without just cause. The third expensive mistake landlords should never make is by not providing proper notice. And proper notice is a pre-eviction notice you have to give to the tenants to make sure that they are aware that the lease is coming to an end. And this is in relation to month-to-month lease agreements where the tenant has been at the property for a certain amount of time, In residential leases, if the tenant has been at the property for under 1 year, you can give the tenant a 30-day notice to terminate the tenancy. If they've lived in the property for longer than 1 year, a 60-day notice is required. In certain instances, a separate notice is not required when there's a fixed term lease, because that has already given the tenant notice that the lease will be expiring on a certain date. If a notice has not been given to the tenant before an eviction is filed in court, the tenant can use that as a defense and have the eviction case thrown out, in which case the landlord has to start all over again by giving a proper notice and waiting for the notice period to run out and then filing the eviction again. But it could open up the landlord to liability for wrongful eviction, and potentially could cost the landlord fees and costs for the tenant's time, and even attorney fees for defending the first case. So those are the 3 expensive mistakes landlords should never make in California. If you have any questions, get in touch with us or contact a lawyer, an attorney who's very specialized in this field for advice. Thanks for watching.